Thank you. Great. Thanks very much for coming out. So the book, Why Tolerate Religion, has a provocative title and then a less provocative answer. The answer, in short, is the reasons for religious toleration are not specific to religion. But now let me say a little more about what I mean by that. What I'm concerned about is a fundamental inequality that exists currently in American law, but not only in American law. It's true in the law of Canada, countries in Europe, basically the law of all the sort of basically liberal democracies in the developed world. And the inequality is this, which is that people who have a conscientious objection to complying with a particular law that is based on their religious beliefs can sometimes get an exemption from the law. Those who have a conscientious objection to a law that is not based on their religious beliefs, but their moral beliefs, their cultural, their family traditions, whatever the source of their conscientious objection might be, they typically have no standing to ask for an exemption from the law. So there's an inequality in the law between religious and non-religious claims of conscience. Ironically, this is true even in societies in which the fundamental constitutional documents or the founding charters specifically mention liberty of conscience as well as religious liberties as fundamental rights of individuals. That's true in Canada, it's true in the European Convention on Human Rights, and yet ironically the only challenges to laws that are successful are those that come from religious challengers. Now, there's one exception to that, which I do want to note at the beginning, and it is an exception in all the Western democracies, and that is for challenges to military conscription or a military draft. In all these countries, recognize conscientious objection to military service, even if not based on religious belief or religious faith. In the United States, it's complicated in the United States because the First Amendment of our Constitution recognizes a right to the free exercise of religion. It says nothing about conscience, right? Now, we know why it mentions only religion, because it was the late 18th century. Europe in the early modern period went through a series of wars of religion in which people slaughtered each other over religious differences, and religious toleration arose as a sensible solution, right, to endless war between competing groups. But the Constitution, our Constitution, mentions only the free exercise of religion during the Vietnam War period, and there's a few people in this room old enough to remember that. The question arose whether conscientious objectors to military draft, this is the last time the U.S. had military draft, whether you had to have a religious conscientious objection to war or whether you could have a non-religious conscientious objection. And the United States Supreme Court actually decided, and this is the only example in the United States, the United States Supreme Court decided that you could have a non-religious conscientious objection to military service. Now, the important thing to know is that this was presented not as a constitutional decision. It was not a matter of interpreting the First Amendment of the United States Constitution. It was presented as a matter of statutory interpretation. That is the Selective Service Registration Act, which still exists and which requires everyone at age 18 to register for a possible draft. Many of you probably don't know that, but it's still there. The Selective Service Registration Act was interpreted by the Supreme Court to include non-religious conscientious objection. Now, it wasn't an accident they made this as a matter of statutory interpretation, because if they had said the First Amendment of the Constitution protects non-religious conscientious objection, that would have opened the door to all kinds of challenges to all kinds of different laws. So that's just by way of what the basic problem is. Now let me say a little bit about why I frame this in terms of toleration. And I want to talk a little bit about the idea of toleration. So the basic idea of toleration is fairly simple. Toleration arises when one group disapproves of the beliefs or practices of another group. Right? You have no need for toleration if one group is just indifferent to the other group. It's got to be the case that one group actively disapproves of beliefs or practices of another group's and yet decides to put up with these beliefs and practices. Right? That's the sort of basic element in all kinds of toleration. And the reason that's at issue when we're talking about exemptions from the law for conscientious objections, I think can be illustrated nicely by a case that comes from Canada in the year 2006. So let me describe the case to you. This case involved a boy enrolled in middle school, probably roughly like the 8th grade. He was taken to the principal's office because he was carrying a knife on his belt. Unsurprisingly, the schools in Canada prohibit the school children from carrying weapons, and so they wanted to throw him out of the school. The complication in this case is that the boy was a practitioner of the Sikh religion. And in the Sikh religion, boys at the sort of age of maturity, roughly 13, among the sort of rites of passage to manhood in that religious tradition, arises an obligation to always carry a ceremonial dagger called a kirpan. Okay? And that's what this boy was doing. He had his kirpan. Now, his kirpan was an actual dagger. Some Sikhs, in fact, carry kirpans that are wooden or plastic, but in his particular sect, it was a real dagger. His family went to court and challenged the law prohibiting the carrying of weapons. They asked, in other words, for an exemption from the law. And this is why it's a problem of toleration, because the state, the community, disapproves of the carrying of weapons in schools, and then a particular religious believer comes forward and says, because I have a religious obligation as a matter of conscience to always carry the kirpan with me at all times, I want you to tolerate it in my case, even though you wouldn't tolerate it in any other kind of case. And indeed, the Canadian Supreme Court, and we can talk more about this if people are interested in Q&A, the Canadian Supreme Court decided that the school did have to accommodate him and permit him to carry the kirpan in the school. Now, interestingly, as just a little side note, the same issue has arisen about whether adult men who are practitioners of the Sikh religion can carry their kirpan in courtrooms and on airplanes. And the Canadian Supreme Court said no to those, okay? No exemptions there. So 8th graders, that's okay, but not people in courtrooms and on airplanes. And the reason they gave was, I think, really quite implausible, which was they said the classroom, and now many of you are only a few years probably from middle school, so you will remember this. The middle school classroom is a place in which there is a cooperative and friendly relationship between teachers and students. Maybe that's true in Canada, but I'm skeptical. And of course, it leaves out the crucial thing, which is that courtrooms, right, have armed guards. Classrooms don't. Yet they nonetheless said no kirpans in the courtrooms and no kirpans on the airplanes. So even when exemptions are recognized for conscientious objections based on religious practice, there are still sometimes limits to how far those exemptions will go, and the Canadian case illustrates that. Now, let me say a little more about toleration, because what I'm interested in is what I'm going to call principled toleration, right? And by principled toleration, I mean cases where we put up with beliefs or practices we disapprove of because we think it's the morally right thing to do. Now, that's a very demanding kind of toleration, right? Because you start with saying, I really don't approve of this particular practice or these beliefs, but I think the morally right thing to do is to let those people continue doing what they're doing. There are other ways of putting up with other groups that don't involve principled toleration, right? So famously, the English philosopher Thomas Hobbes, right, thought that if we lived in the state of nature without the benefit of government and a state regulating our lives would be nasty, brutish, and short. We would have the war of all against all at all times. And one kind of toleration, but not principled toleration in my sense. Sometimes by toleration, people really just mean what I would call Hobbesian compromise. Namely, one group puts up with practices and beliefs they disapprove of only because they don't think they can get away with exterminating them. Right? They think it's too costly to try to stamp out those practices. In essence, I think the tradition of religious toleration arose in Europe after the early modern wars of religion for essentially reasons of Hobbesian compromise. That is, different religious groups still very strongly disapproved of the beliefs and practices of the other groups, but they realized that no good would come for anyone in trying to, endlessly force and convert others to their particular beliefs. I'm not interested in Hobbesian compromise, even though I think in real political life it's quite important. So I don't mean to say it doesn't matter or it isn't sometimes the only thing we may be able to achieve in a society where groups have very conflicting views about how to live, what's important, what's valuable, and so on. But I'm interested in principled toleration because in a way principled toleration provides a more secure foundation for toleration because it's not based on the Hobbesian calculation, could we get away with suppressing the beliefs and practices of the group we disagree with? It's based on the sense even if we could get away with it, we ought not to do it. That there is some important moral, political value that is served by allowing others, even if we disapprove of their beliefs and practices, to nonetheless be able to engage in them. Now, in my book, I consider two main lines of argument in sort of the modern canon of political philosophy. Now, for those of you who have studied philosophy, this will be quite familiar, but for the many of you who haven't, I do want to run through these arguments in a little bit of brief detail. One line of argument for principled toleration comes from what's often called the Kantian or deontological tradition in modern moral and political philosophy. The Kantian part is after the 18th century German philosopher Immanuel Kant. The arguments I consider derive from an important American political philosopher, John Rawls, his 1971 book, A Theory of Justice, which had a strongly Kantian element, and I'll say a little bit about his views. But then interestingly, the other line of argument for principled toleration comes from the utilitarian tradition, an opposing tradition in moral philosophy associated in particular with the English moral political philosopher John Stuart Mill in the 19th century. Now, what's interesting and significant about both of these is that they give us some plausible reasons for thinking principled toleration is a good thing. They do so appealing to somewhat different initial moral intuitions, but they both support the conclusion that there's no reason to think that toleration of religious claims of conscience is more important than toleration of non-religious claims of conscience. And that's what I meant when I said at the beginning that the answer to the question, why tolerate religion, the reasons are not specific to religion. They are reasons to protect a general liberty of conscience. Okay? Now, let me say a word about these two lines of philosophical argument. And I should say I'm going to speak for a total of about 45 minutes, so we should have plenty of time for questions, clarifications, and so on. Let's start with the Rawlsian argument. John Rawls wrote a book in 1971 called A Theory of Justice, right? And he wanted to think about the questions, what are the fundamental principles of justice that ought to govern a society? And he proposed a thought experiment that would allow us to identify these principles. And the thought experiment went something like this. He said, imagine people who are going to make a social contract, establish the basic principles of a society, all right? But deprive these people of all the kinds of information that would make them partial, biased, self-interested, and so on. So don't let them know what their religion will be. Don't let them know whether they'll be rich or poor, black or white, in the majority or the minority in their society. And Rawls's thought is that when you deprive people of the kind of information that would make them biased and self-serving in their judgments about what would be fair and just, you'll get closer to genuine justice. Now, of course, the people in what Rawls called the original position, right, this thought experiment of this situation where we're going to arrive at the fundamental principles of justice for our society, they can't be deprived of all information. They have to know something about human beings. Right? They need to know that human beings need certain resources in order to survive. And one of the things they need to know, according to Rawls, is that they will all have a sense of conscience. Okay? Now, by a sense of conscience, let me just say what I mean, but I think it fits perfectly well with what Rawls is after. The sense of conscience, right, is the sense that we all have that there are certain things that we must do, they're not negotiable, and certain things we must not do, right? Certain things that we absolutely have to do regardless, and certain things we absolutely can't do no matter what. And people's sense of conscience can be informed by their religious traditions, their cultural traditions, their moral and political beliefs, their experiences in life, and many other things. Okay? Rawls says people in the original position know that they have a sense of conscience, and they know that to be forced to act contrary to their conscience would be a very severe hardship for them. And Rawls thinks if you add that assumption into the original position, that people will agree on a principles of justice, principles of fairness that include strong protection for liberty of conscience. So from the assumption that the people in this original position are deprived of the information about whether they're in the majority or the minority, whether they're religious or not religious, what religion they are, whether they're wealthy or poor, and so on, but they know they'll have a sense of conscience, they will choose principles of justice that protect a broad liberty of conscience. But Rawls is very explicit. There's nothing in this that is peculiar to religious conscience, though it's clearly included in the liberty of conscience. That, in simplified form, is the Rawlsian argument. Now, let me say a little bit about Mill's argument, which operates in a different way, but arrives at a very similar conclusion. Mill was a utilitarian, right? He thought the right thing to do was whatever would maximize happiness or well-being. Right? Utilitarianism was an important tradition in moral and political philosophy to the present day, and Mill was probably its most, or one of its two most sophisticated defenders. Now, Mill thought that knowledge of the truth, discovering what is true, right, would increase utility. Right? So discovering what's true, acquiring knowledge of the truth, will in fact increase human happiness and human well-being. And then he asked the question, under what conditions will we be more likely to discover what is true? And one of the conditions he thinks is essential is that there be a very broad liberty for expression, thought, and also conscience. And let me just say a little bit about the arguments specifically about liberty of expression, which are the ones that he's probably most famous for and that have actually had a significant impact on Anglo-American law. Mill thought, look, if we're going to discover what is true, right, we have got to be confronted by contrary views. Now, why? Well, Mill was what's known in philosophy as a fallibilist. Right? He thought all our knowledge comes from experience, and we can't be certain that what we now think is true might turn out to be false. We might encounter contrary experience that would change our views. Yeah? So we can't be certain we know the truth right now, and we won't find out whether what we believe is true unless we are confronted with contrary opinions, because the contrary opinions might in fact contain important elements of the truth, or they might be entirely correct, right? Even if it might be we're totally wrong and the others are right, or it might be we're partly right, partly wrong, but we won't see that unless we're forced to confront contrary views. But more interestingly, Mill thought even if everything we believe is true, right? We all like to think that. Even if everything we believe is true, it's still valuable to be confronted by contrary but false views. Why? Because Mill thought it prevents you from becoming dogmatic in your beliefs. It forces you to think about what are the reasons and evidence that support what you believe, and you wouldn't have to do that unless you had to confront contrary views, even if you conclude that those contrary views are false. Right? So a broad liberty of expression is going to be important for discovery of the truth. But there's another aspect of Mill's view which is important to be aware of, which is Mill didn't think that truth was simply confined to the realm of the empirical sciences, factual questions. Mill thought that there were truths, better and worse answers to questions about how you ought to live. Right? What are the best ways to live? Right? And Mill thought we can only acquire knowledge about the better and worse forms of life that are available to human beings if we encourage what he called experiments in living. That is, if we tolerated, right, forms and styles of life that we might disapprove of, right, but might nonetheless give us some evidence about the value of those kinds of lives. Right? And so this is where liberty of conscience gets a particular register in Mill's argument. That is, there is value in allowing people to act according to their conscience, even if we think it's wrong-headed, because it provides us a kind of empirical evidence about whether that way of life is a good form of life or a bad form of life. And Mill famously thought that the way, right, to figure out which kind of life is best or worse or better or worse would be to consult moral experts, where the expert is someone who's had experiences of both kinds of lives and experiences of both kinds of happiness. Right? So Mill famously says, and some of you may have heard this remark, he says, it is better to be Socrates dissatisfied than a pig satisfied. Okay? Now here he's rejecting the view that Jeremy Bentham, the late 18th, early 19th century utilitarian, held. On Bentham's view, all happiness was the same, right? It was all a matter of a certain psychological state of pleasure, right? And the absence of pleasure, right, there'd be pain, and all pleasure and all pain differs only in quantity, not in its quality, right? So the pleasure of attending this lecture, right, is essentially the same kind of pleasure of drinking beer or going to a football game. And I'm sure that's obvious to all of you, right? This is what Bentham thought. Mill thinks no, pleasures differ qualitatively as well. And that was his point with Socrates and the pig, right? The pig rolling around in the mud is extremely content. And Socrates, with his endless questioning of everything that people take for granted, seems endlessly discontent. But the quality of his happiness, the Socratic happiness, Mill thinks is higher than that of the pig. It's not clear to me he's actually entitled to that conclusion, because I don't think he or anyone else ever had the relevant experience of living like Socrates and living like the pig. So we may be selling happy pigs short on this view. But the crucial thing is, Mill thought that this broad liberty of expression, thought, and conscience, in which people can experiment with different ways of living, was also essential to giving us knowledge of the best forms of life. And that kind of knowledge is also going to contribute to utility or happiness. Now, once again, as with Rawls, even though it's a very different argument framed in terms of the relationship between truth and the maximization of utility, Mill arrives at a very similar conclusion. Namely that there has to be a broad protection for the liberty of conscience. Nothing in the argument is specific to claims of religious conscience. And I go on to argue in the book in some detail that if you find these, either one or both of these kinds of arguments plausible, then it really isn't justified. The legal status quo that we have is not justified, in the sense that it isn't justified to allow someone with a religious claim of conscience the legal opportunity to ask for an exemption from the law, but to deny that to someone with a non-religious claim of conscience to a particular law. And so I conclude in the book by taking up the question, well, if this is right, if the inequality between religious and non-religious conscience isn't defensible, well, what should we do? And two natural possibilities suggest themselves. The first one, of course, is just to expand the range of exemptions that are available to everyone who has a conscientious objection to a law. Now, no legal system has gone this route, and I predict with some confidence no legal system will go this route. Because, of course, one implication of it, right, is that every law is potentially vulnerable to conscientious challenge, and the courts will be flooded, right, with conscientious objectors to all kinds of laws, and then the courts will be put in a position they do not like to be in, which is they will then have to evaluate whether or not the conscientious objection to the law is legitimate. Now, courts are good at some things, but one thing they are not particularly good at is peering into the soul of human beings, which is in essence what they'd be asked to do here. Even in the context of religious exemptions in the United States, the official doctrine of the courts is that to have a conscientious religious objection to a law, it doesn't have to be a recognized religion, right? It just has to be a sincere religious conviction. That's what they say. The reality is, in all the cases where religious objectors succeed, their objections are recognizable as being related to religions and religious traditions we're all familiar with. And I think there's a very simple reason for this, which is because the courts aren't really good at peering into a person's soul, they like evidence, right, that they can get a handle on that this is a genuine conscientious objection, right? So during the Vietnam War, Quakers had a very easy time. If you could prove you were a Quaker, everybody knew that it was central to the Quaker religion that pacifism was morally required, right? Participation in war was forbidden. And so what you needed was evidence, is this person really a Quaker? Well, you can get that kind of evidence, right? Do they attend Quaker religious services? Are they familiar with the texts and traditions and so on and so forth? Okay? When the Supreme Court said non-religious conscientious objectors to military service could also get exemptions from military service, there arose, and again, a couple people in the room may be old enough to remember this, there arose sort of an industry of advice about how to prove you are a non-religious conscientious objector, right? Write letters to the editor, write op-eds, expressing your pacifism and explaining its moral basis, and collect all these so that you can then go, right, when you're called for the draft and say, no, look, I'm not a Quaker and I'm not a part of a different religious tradition that's opposed to war, but I am actually still a pacifist. And that was an attempt to deal with that problem. I don't think the courts are going to go that route, right? They're not going to want to open the door to conscientious objections across the board. But I think there's a competing consideration, right, that counsels against a massive expansion of exemptions. And so I defend the view in the book I call the no exemptions approach, but it's not really no exemptions at all, and I'll qualify why in a moment. But the idea is this, which is in a just society, and that's a big precondition here, if we're in a just society, then the laws that are enacted ought to promote something like the general welfare. I take this idea from the French philosopher Jean-Jacques Rousseau. Laws ought to promote the general welfare, and sometimes granting exemptions to laws will undermine the pursuit of the general welfare, so it has a very serious cost. And let me give you an example. Exemptions to mandatory vaccination schemes. Vaccination works, right, only because of herd immunity. That is, no vaccine protects you 100%. But if just about everybody is vaccinated, the particular infectious agent won't get a foothold in the community, and so there'll just be less and less of it around. And that's how the smallpox vaccine worked and the polio vaccine and so on. Particularly in the Western United States now, they're handing out exemptions to mandatory vaccination schemes rather liberally. Indeed, in California, though they've now changed this, because you may have heard California has had outbreaks of whooping cough, which had been eliminated by vaccine, outbreaks of measles, which had been eliminated by vaccine. But in California, they used to hand out not only religious exemptions, people who had a religious objection to vaccination, they used to hand out what they called philosophical exemptions. Now, to me, as a lawyer and a philosopher, right, I would think to get a philosophical exemption, you have to have an argument or a reason, right? Not in California, right? In California, all you had to do was check the box, philosophical, which is nonsense, right? Because it basically means people who had, whatever crackpot theory about vaccination, they could just check that box and they were out of it. I think there probably shouldn't be any exemptions to mandatory vaccination schemes, conscientious exemptions. I, of course, don't think that someone at risk of a life-threatening reaction to vaccination, and there are people, should be forced to be vaccinated, right? But that is, as it were, we don't have laws that require other people to sacrifice their life for the entire community. Okay? But that would be a very small number of exemptions for a different kind of reason. Mandatory vaccination schemes promote the general welfare. I think that's uncontroversial, and they don't work if you start giving out exemptions. By contrast, I think there are a lot of laws where exemptions, right, don't affect the ability of the law to promote the general welfare. And in those cases, I think both religious and non-religious individuals should have a right to ask for a conscientious exemption from the law. And I'll conclude by just giving you an example of the kind of law I have in mind here. So the laws in most states require people to get a photograph for purposes of getting a driver's license, and the law usually requires that they not wear anything on their head when they get the photograph. The rationale for that is that the photograph has to give a clear picture of the face so that you can be identified by a police officer, for example, if you're pulled over and they ask to see your license. Well, there are many different religious traditions in which wearing something on the head is required. Orthodox Jews wear a yarmulke, Sikh men wear a turban, and so on. Okay? I think exemptions in those cases don't really affect the general welfare. In my terminology, they are not burden-shifting exemptions. That is, you can still generally identify someone quite well if they are wearing a turban. Right? And so it seems to me, as it were, perverse and a bit gratuitous to insist, no, they have to remove it. That's a case where the exemption is still compatible with the point of the law. On the other hand, right, there is certain kind of religious headgear, in the extreme case the burqa, that completely obscures the face. Right? And if you give an exemption in that case, that does defeat the point of having a requirement that you have a photograph on your license. And to my knowledge, no jurisdiction in the United States, there has been litigation about this, has granted an exemption in those cases. And I think basically for a very sensible reason. So let me conclude by saying that the view I end up defending is actually very close to the view that the late Supreme Court Justice Antonin Scalia defended in a 1990 Supreme Court opinion called Employment Division versus Smith. And let me just tell you about Employment Division versus Smith and the position that Scalia adopted in his majority opinion. Smith was a member of a Native American religion which required, as part of its religious rituals, the chewing of peyote. I will not ask whether anyone has chewed peyote here, but I am told that peyote is quite disgusting, okay? That is, you're probably, and the thing is, peyote is also a narcotic. Sorry, that's the other important part of this. But it's not, as it were, a pleasant narcotic to consume. There was a notorious case, I think it was in the early 70s, where the Church of Marijuana was formed and sought a religious exemption from the marijuana laws, right? Courts threw that out. This was not a religion, it was just a fake. They wanted to smoke dope. Peyote is not pleasant, but it was part of their religious rituals that you had to chew some of it. Now, Mr. Smith, unfortunately, also worked for a state agency that was involved in treating drug offenders. and helping rehabilitate people from drug addiction. As a result, he was regularly tested for narcotics. He tested positive because of the peyote, which he had to use as part of his religious faith. He tested positive, he was fired. He then applied for unemployment benefits and was denied unemployment benefits because you can't get unemployment benefits if you lost your job because you broke the law, right? And that's why he's suing the employment division, asking for an exemption, a religious exemption, okay? So that he could get his benefits. In the majority opinion by Justice Scalia, what he said is, look, if a law is a neutral law of general applicability, and by neutral here we mean the purpose of the law is to promote the general welfare, not really to persecute some group because of their religion, right? And that was clearly the case with the Oregon law. Oregon had a classification of all different kinds of narcotics, right? They had reasons for prohibiting narcotics. There was no indication they were out to get this particular Native American religious sect, right? It just had the unfortunate implication that it did. Scalia said if you have a neutral law of general applicability, in my terms, a law that's actually promoting the general welfare, right, then the state does not have to give exemptions to the application of that law. Okay? Now, you might be wondering if that was a decision by the U.S. Supreme Court, then why am I talking about this whole problem? Well, the answer is because the 1990 decision by the Court in Employment Division versus Smith was met with an enormous political backlash. And laws were enacted at the federal and state level that reestablished basically religious exemptions. Many state Supreme Courts interpreted their constitutions to require exemptions from laws that burden the free exercise of religion, and so on. So while it's not been overruled, it has relatively little reach compared to what I think Scalia thought its import was. But it seems to me that the basic idea he had in Employment Division versus Smith was a sound one, but it is not the law in the United States today. I think that's a good place to stop. Thanks so much.